And we are the Coalition, loud and proud, outrage porn-free, civilly disobedient media, broadcasting live on the worldwide Coalition Radio Network at coalitionradionetwork.com, facebook.com/the Coalition Radio, on the mighty, mighty Twitter at Coalition_radio, and of course our original mothership at coalitionradio.us, where interviews, articles, data, content dating back to 2012 can be found. And let me tell you, it's interesting how people, individual causes, issues, data, ages, sometimes well, sometimes not so well. So we've got a very special show this afternoon. Normally we broadcast this at evening, but we had the opportunity to bring on a guest who has got literally an unparalleled look, experience, deep dive into the world of First Amendment. He is, of course, Lawrence Walters. He is the, if you will, the principal of the Walters Law Group, a prominent law firm concentrating in internet law, intellectual property, gaming, First Amendment issues. According to his website and our experiences, Mr. Walters has developed a passion for protecting civil liberties, in particular online speech and expression. He has devoted over 30 years to defending constitutional rights and protecting free expression. He's an accomplished civil rights advocate, a widely published author, and a well-known public speaker. NBC, ABC, PBS, BBC, CBC, FNC, MSNBC, CNBC, and CNN. He's consulted as a national expert on legal issues pertaining to freedom of speech and, of course, the internet, which is truly, we can all agree, regardless of our political perspective, has become a battleground for the First Amendment. Timeless, varied publications over a spectacular career. He also serves on the board of something called the Woodhull Freedom Foundation, an organization that we will go into depth in the latter part of the show as we not only discuss suppression issues, but we also tackle issues that this show has focused on for a number of years, particularly decriminalization of sex work, FOSTA, SESTA, and, if you will, the war on sex workers. Attorney Walters, welcome to the Coalition. You grace us by your presence. Thank you for joining us this afternoon.
You're too kind. I really appreciate the opportunity to be here and address your audience, answer your questions. This is going to be a good show. I'm looking forward to it.
Absolutely. First of all, I have to ask you, firstamendment.com, and of course I'm referring to your law firm's website. How did you get that? I know you've earned it, but how did you get that domain?
Right. Well, to be honest, I was one of the first lawyers that was really focusing on internet law issues. Mm-hmm. And it was early on in the development of the internet, I suppose 96, 97, and we started representing a lot of webmasters. And I was a First Amendment lawyer before, the internet popped up, and was representing video store distributors and protesters and you name it. But once the internet started to really take off, I decided that I've got to establish my space. Firstamendment.com happened to be available, and it was the perfect fit for our law firm. Probably could never get it now, but it was early enough where I was able to pick it up for a reasonable fee. Excellent.
Well, this show revolves primarily around two principal amendments, if you will. And I have a question for you in a second that I ask every attorney, every activist who comes on the show. But this show I would like to think of as sort of the Providence, Rhode Island home of the First and Fourth Amendment. The question I often open up with, as an attorney with a lifetime of practice surrounding constitutional law, if you were to choose one amendment that is under the most arrest, the most attack, and is it most at risk, which one would you choose from our Bill of Rights?
Right now, I'd absolutely have to say the First Amendment. Mm-hmm. For the last 20 years, it would probably have been the Fourth Amendment with the war on drugs and the Patriot Act and efforts to burst into our privacy and surveil our communications in our homes. That's a related First Amendment issue, given the chilling effect that those unreasonable searches and surveillance has on our free expression rights. But right now, I'd absolutely have to say that First Amendment rights are critically imperiled, both by government action, indirect government action, as we'll talk about with FOSTA, and by private platforms.
Right. How did you become a pioneer? And I don't use that term loosely. You know, as a young man, my heroes growing up, for example, were people like Nat Hentoff, the great longtime columnist for the Village Voice, who interestingly enough covered both jazz and First Amendment rights, who I think may have been one of the earliest to coin the expression free speech for me, but not for thee. And as early as the 80s was actually, you know, writing about the attack on free speech at college campuses, which is now, as folks have aged, become very much the number of folks who are still attacking the First Amendment. What was your personal experience that brought you into this form of law?
I had some good mentors when I was in college and law school, and they got me very interested in dissenting voices and making sure that all points of view were heard. I've been fascinated with the marketplace of ideas and how the truth will eventually bubble to the top as a result of robust debate and discussion and the airing of ideas in the marketplace. And I had a few folks in my legal training that were very focused on First Amendment issues. Primarily, they were professors and academics and teachers that they did okay in their professions. But I know that I wanted to be a practicing lawyer. I wanted to be in the courtroom. I wanted to be representing clients. I wanted to be making law, not just talking about it. And so I kind of, kept my eyes open for opportunities. And like any starting lawyer, I did what I had to do in a law firm, starting out representing insurance companies and banks and construction companies and you name it. But then we saw in Daytona Beach, Florida, a very unusual occurrence. We had a state attorney who had decided that he was going to clean up Daytona Beach's image. And one of the things that he decided to do was to rid all of the adult video rentals from the back rooms of video stores that were operating in the location. And so he arrested these mom and pop video store owners on a number of obscenity violations, claiming that the X-rated videos were obscene in violation of Florida law. And he paraded them out in handcuffs, and he was, it was a big political move to try to justify his moral culture war. But then I saw that he was doing something more. He was sending letters to these video stores demanding that certain videos be taken off the shelves that he disagreed with or thought were inappropriate. And these weren't adult videos. These were just, some R-rated videos, I think pink flamingos, other things that he just didn't like. Right. And I said to myself, there's got to be something wrong with that. You can't just simply send the sheriff into a video store and demand that stores be taken off the shelf as a state attorney. So I looked into it a little bit as a young lawyer, and I decided, let's see if there's something that can be done to help these people. I went to the courtroom while they were being tried for obscenity cases, and I walked up to the lawyer who was representing them. He was a corporate lawyer, really didn't know what he was doing, had never been in a criminal court in his life. And I said, hey, do you need some help? This doesn't seem right. I didn't really know what I was doing either, but it didn't seem right, and it seemed like something needed to be done to fight back. And this guy said, absolutely, I can use all the help I can get. Let's, bring you on as co-counsel, and we'll try to knock these charges out. So I started representing these folks free of charge, and we got all the charges dismissed. We sued the state attorneys, and we stopped the efforts. We created an anti-censorship movement in Daytona Beach called No Censorship. And it was a time when you'd see every other car had a bumper sticker that said no with a slash through it, censorship. And it was a really interesting grassroots movement that showed me that people believe in the First Amendment, that if they're enlightened to the arguments, if they understand an abuse of power and the chilling effect on free expression that these kinds of prosecutions can create, that they'll respond to it, that they'll back the rights of citizens, even if they don't personally agree with the type of material that the video store owners were selling or what they were saying. And that enlightened me to understand that this is an area I wanted to devote my career to. These are people I wanted to help. What I didn't know at the time is that there were folks in the audience watching those trials from California who were making those movies. and who were very concerned that if the movies would be declared obscene at that time, and this was the late 80s, the stuff that they were currently making was really in trouble because they were prosecuting movies like Deep Throat and The Devil and Miss Jones and things that had been out for maybe 15, 20 years already. And so they were very concerned about these cases and watched me handle the trials and ultimately said, I like your style. I like what you did up there. We'd like you to do more work in this area and help defend First Amendment rights. And so that kind of gave me my start.
Somewhere John Waters is smiling. He's not sure why, but he's smiling. And, and so is every artist. What was the Supreme Court Justice, and I'm mangling the words, I'm sure, something to the effect of, I know obscenity when I see it, in terms of literally a legal standard. I wonder how many prosecutors, do-gooders, careers have died on the hill of fighting art like Pink Flamingos and the works of people like John Waters, or even some of the, believe it or not, the more extreme artists of the time. That's
by the way, the full quote there is obscenity. I know it when I see it, and this ain't it. That's the part that's often left out of that quote.
And actually, you're right, and that's the best part of the quote, because ultimately, did that not create sort of a extra legal community standard? It was really up to folks' interpretations as to what constituted obscenity. Wasn't that sort of the beginning of the end, if you will, of some of the more virulent laws?
Right. It helped develop the Miller test for obscenity, which itself is very complicated and vague and up to local community standards. It's really one of the few crimes that you don't know whether you've committed it until a jury comes back and says you're innocent or guilty. But it does rely on what the community tolerates and what is acceptable in the community. Mm-hmm. When you think about that now in the age of the internet, what is the community? Is there really a community standard related to adult materials in every geographic location? I mean, we have more in common with our social media friends than we do with our neighbors. Most people barely know their neighbors down the street, but they might know people in other countries very well if they interact online. So it's a very unworkable standard, but it is still the standard today. But that quote did help develop the more kind of loose interpretation evaluation of obscenity.
How important is it? And you're right. By the way, at the Libertarian Party, we just went through an extreme debate over what constituted a place and whether or not the internet constituted a place for purposes of the bylaws of an organization to have and hold a convention. So that debate, I believe, continues on. But how important is it to have that local control, whether it be your amen choir on the internet and or a locality's consent over, I'll call it bricks and mortar expressions of First Amendment adult behavior?
It's an interesting question. It comes down, in my mind, to where is the expression occurring? Mm-hmm. So if you have online content that's distributed from a server in Texas and that's available throughout the world, there's no logical reason for that content to be judged by the standards of some local county where it happens to be downloaded or accessed. Mm-hmm. The California federal appellate courts have recognized this and have said that internet communications need to be evaluated by national standards at the very least. That there's the idea of local community standards is no longer workable for online communications. I suppose if you have some rally or performance or local ballet or something that's occurring in some community where there's a intersection with the community, an impact on the community in some way, perhaps there's a better argument for local control.
Right. Now, your firm has branched out into a wide array of service, and I want to discuss that briefly because a number of our listeners, both in this show plays and will replay on Twitter, as well as Facebook and a variety of other social media platforms, interestingly enough, ironically enough. But we have developed quite a following within the adult entertainment community. I guess you would consider us an ally in that we've worked very hard at the coalition to bring on voices literally from around the country and in some cases around the world of folks who are involved in the decriminalization of sex work. And, as a libertarian base / liberty-themed network, it's critical to us that we provide whatever support we can at a time when, as we'll discuss later in the show, electronic means here in the United States, yes, the land of the brave and the home of the free, are being suppressed. So interestingly enough, to this question, so many of those platforms now exist on a variety of islands surrounding Great Britain and the northern coast of Europe in terms of where they're legally headquarters. And so American internet users have had to understand a whole variety now of extensions. The U.S. doesn't matter so much. Extensions like .ch matter even more. But you branch into a whole variety of services. Now, for example, for the layman, something like Section 2257 records. Can you give us a content production procedures, website operations advice? Talk to us about that. That's really the nuts and bolts of the adult entertainment community.
Yeah, a lot of what we do is trying to get adult entertainment operators, website operators, content producers, platform operators compliant with the wide variety of federal laws and international laws that govern their operation. As you can imagine, adult entertainment is a very popular political football, and it's easy to convince lawmakers to pass laws to crack down on adult entertainment. There's not a big lobby advocating for the rights of sex workers or the adult entertainment field, although it's growing, certainly. The sex workers have found their voice as a result of the recent FOSTA, SESTA disputes. But over time, the adult industry has been subject to just a wide variety of burdensome regulations and laws and requirements. And that means that lawyers have to get in and try to help people understand how to comply, how to stay out of trouble, what's legal, what's not, what's obscene, what is indecent, what is restricted to minors, how to verify the age of models, how to make sure that you're not promoting or facilitating sex trafficking. And there's a whole wide range of issues that we help people understand. And then when you get to the broader issues of things like privacy rights, as a user of adult entertainment websites, you're giving up a lot of personal information to the operators. And the operators have responsibilities and how to treat that information, how to keep it private, who they release it to. Particularly in the adult entertainment field, it's very sensitive information. Even the identity of every user of an adult website is a critical piece of private information. So, we help people understand those obligations. You mentioned 2257. That's a law that's been around for some 20, 25 years, been challenged repeatedly. We believe it's blatantly unconstitutional because it singles out a particular type of speech, being sexually oriented speech, for different treatment. It's a content-based restriction on speech. And so in other words, in order to create adult content, sexually oriented content, you have to go through this rigmarole of document production and retention and categorization of information, checking of IDs, identification of URLs and prior stage names and maiden names, and cross-referencing them in a certain manner. This is all designed to scare people out of the industry, to make it overly burdensome, overly complicated, so that people look at it and say, well, I don't want to risk going to jail for 5 years, so I'm just not going to do it. It's what we call the chilling effect of unconstitutional laws that restrict speech.
What type of cost does this, not in terms of your service, but in general, to an important part of the economy? And folks need to understand that despite their own personal, let's just say their public expression of their personal views, which may differ from their actual personal behavior, as we know, despite all of that, this is a significant part of the American economy. Tens of thousands, countless people are employed by this, very often in conditions that pre-legislation, the legislation that was designed to save them represented ways to earn a living and ways to be entrepreneurial. All of this, what does this represent as a cost to this industry?
It's a tremendous burden, both in terms of legal compliance and resources and human personnel that are required to understand and implement all these obligations. As you mentioned, adult entertainment has been a significant source of the economy for a long time. It's actually driven many of the technical innovations, from the VCR to the internet to affiliate marketing. you name it. The adult entertainment industry was on the cutting edge of all of that and drove the advancements. But now that we're living in COVID-19 times, we are seeing a tremendous expansion of the adult entertainment industry for the performers who are stuck at home or individuals who've never performed in adult entertainment and have determined for whatever reason that this is how I'm going to keep myself alive. This is how I'm going to provide for my family, for my loved ones, or my children, with businesses shutting down and no options available in terms of making a living other than getting online. We're seeing a tremendous expansion in adult entertainment, and that represents a larger cross-section of the economy and individuals who are impacted by all of these laws that you're talking about.
And if you doubt that, I'll relate a personal experience. Years ago, I happened to attend a meeting of the DVD Forum, which was held in the Los Angeles area, obviously in California. And the DVD Forum served as a technical body to establish, if you will, the technical specifications, the standardization, if you will, of what we've come to know as, well, DVDs. And that's not a simplistic effort. You were talking about engineers from a variety of companies who hold a variety of patents at a variety of levels, and they need to come together to establish standards so it becomes as transparent to the user, the guy who goes to Best Buy and buys a DVD player. Believe me, the word balkanized has nothing on what the original DVD standards were. There were multiple attempts. Interestingly enough, a significant presence at that DVD forum was in fact representatives of the major, at that point in time, largely limited significant players in terms of producing, adult entertainment. These are folks who had years done VCRs. And anecdotally, it was related to me that the reason why you never saw laser discs is that Laserdisc technology was proprietary to the Dutch and the Philips Corporation. And my understanding is, and maybe this is urban legend or not, but their refusal to engage in, you will, conversations with the adult entertainment community so that it became a viable platform to them ultimately ended the life of the Laserdisc. And the embrace, if you will, by the DVD community of the adult entertainment community made the DVD ubiquitous. Even in the age of streaming, we still employ DVDs. So it has a tremendous technical and economic impact on all sorts of technologies, all sorts of lifestyle issues, all sorts of industries. The unintended side effects are enormous for an industry that, again, to your earlier point, the political establishment. And I'm embarrassed to say that Senator Sheldon Whitehouse, one of Rhode Island's esteemed salons, if you will, in Washington, D.C., was one of the co-sponsors, if you will, of the Earn It Act that we're going to talk about. So suffice to say that your firm has carved out a internationally recognized presence both on the commercial side, the philosophical side, and, if you will, the spiritual side of the adult entertainment world. So you're involved with it at every level, and as a result, there's a core competency here, and there's an understanding of the issues that really doesn't exist centralized in many places. And so folks who listen to this and in the future, if you're looking for services, I'll make the plug. Attorney Walters is very professional, but I'll make the plug because it would appear to me that this is really the center, if you will, the spiritual center of the laws and legal challenges surrounding the adult entertainment community. So I congratulate you for that. It's critically important because I've seen firsthand in my interviews with folks who are active sex workers, some of whom were admittedly engaging in survival sex practices, that in the absence of said adult entertainment community, these folks' life choices, not lifestyle, not career, life choices would in fact be limited by, in many cases, an economy that has marginalized them for any one of a number of reasons. So of course we come today to the pressing matter of something called the Earn It Act. And in a way, and I've got to wonder somewhere, is there an office buried, maybe like at the end of the Indiana Jones movie when they took the prized relic and placed it somewhere in a government warehouse. But is there an organization that actually sits there and figures out acronyms so that people can, you can have these really cool acronyms for incredibly odious terms? The Earn It Act stands for the Eliminating Abusive and Rampant Neglect of Interactive Technologies, Earn It Act of 2020. My God, what hellspawn has created this? And I know our president was quick to jump on this bandwagon, President Trump. The This is largely a Republican act per se, but then at the same time, you bring on people like Blumenthal and Whitehouse, and again, you've got the legal spawn of hell. So, what was the motivation for this? And I guess maybe even let's start out even a little bit earlier. This is a direct attack, if you will, on federal legislation that exists to protect platforms from litigation and or criminal attack because they are the hosts. So what is the history of the underlying legislation, and what spawned this, if you will?
Right. Well, the first question I can get into in detail. The second question is easy. It's protect the children. Just like most of the ill-conceived legislation that has been adopted by Congress that impacts the adult entertainment industry, designed to protect the children, but none of it has, and none of it is logically linked to protecting children. It's just a banner, it's a bumper sticker. It's designed to get bipartisan support, make it very difficult to vote against. But what we're dealing with now is Section 230. That's been referred to as the First Amendment of the Internet. It's essentially the federal law that has allowed online platforms to survive, to flourish. It's provided an opportunity for innovation for small and large companies. It resulted in Facebook and Twitter and Yelp and Uber, and every other user-generated content platform that's out there. Because if it wasn't a law, none of these platforms would have been able to survive the hurricane of litigation and criminal charges and administrative actions that would have been brought against them based on their users' activity. So if you can imagine holding Facebook responsible for every bad act of every Facebook user, it's absurd. But that is essentially what Congress is considering now. They started this effort with the FOSTA SESTA law, which chopped off a piece of Section 230 that, as you mentioned, provided this immunity for online platforms and protected them from civil and criminal litigation based on user content. FOSTA SESTA said, well, we're not going to protect you anymore at the federal level if your platform intentionally facilitates or promotes prostitution, or if you are somehow reckless to sex trafficking occurring on the platform. So essentially what the burden is on a platform operator at this point is to look at every video, every picture, every chat, every comment, every piece of text, every graphic on any user content platform to determine if any of it somehow facilitates or promotes prostitution, or if the platform is somehow being used without your knowledge for sex trafficking. If so, you face up to 25 years in prison.
And let's go back to the earliest eras of the internet and talk about platforms like AOL. Folks need to understand that risk capital formed to create the earliest versions of these platforms because, in a sense, there was an exemption from these type of litigious attacks. And so in the absence of that protection, the very platforms that formed the earliest basis, if you will, for commercializing and popularizing the internet simply wouldn't have existed. So, like as in so many cases, government interference, in this case, exposing operators who are running these vast platforms, which are essentially the underpinning of our economy, that innovation never would have happened in its earliest phases if that exemption did not exist. The economy as we know it, the economy as we know, folks need to understand that there is, in providing protection from acts, from the recrimination of acts performed by folks who are not tangible to the operation of that platform, those folks need to be exempted, or we will simply cease to exist as an economy. We can't continue these unhinged attacks on everyone. All
you'd be left with is just curated content that is sanitized and approved by large tech companies with no voices for any dissent no opportunity for any meaningful engagement by users. You would have essentially cable television, and it would be no different than that. And the internet arose out of a libertarian idea of free expression, and every person has equal access to get their voice heard and to make their message. But this is now a significant threat in terms of FOSTA SESTA. And as you mentioned, the EARN-IT Act is the next effort to roll back Section 230 immunity. And we can get into that one if you want.
Right. And so let's set the stage then by briefly talking about FOSTA SESTA, and then later on coming back to some of the legal challenges that you're making to it. So again, feel free to correct me, because sometimes as a layman, I tend to oversimplify. But FOSTA and SESTA essentially sought to, under the guise of protecting against sex trafficking, sought to criminalize all forms of communication, something as simple as a conversation in Twitter or a conversation on Facebook between folks who are working in a quote unquote the active sex community, the sex worker community, and their potential customers, and what ended up being their allies, and organizations that sought to aid folks who were in that lifestyle and wanted a lifestyle change. So what you were looking to do was to criminalize communication between people involved in sex trafficking. What it ultimately did, as in so many cases in the government, it took that one defined step and used it as a cover, as a beard, if you will, for criminalizing virtually every type of communication. And as a result, the folks, particularly women and folks who are trans, are now unable to communicate their work efforts, so they're no longer entrepreneurs, forcing them, if you will, back into an era, the seedy era of pimps and controllers. Irony, right? You're creating an environment that which you were seeking to escape. There's a surprise. You took away the ability of sex workers to screen their clients by using commercially available databases by which were generated by the free market, that terrible free market, which helped ensure the safety of folks who were working in commercial sex. So what you had is, and the statistics are quite raw, what you've done with government intervention in order to save us from ourselves is create a hostile environment for sex workers, which is filled with physical danger and has resulted in countless deaths in the space of what, a year and a half? And the very...
The data is clear on that. It essentially required sex workers to engage in sex work in its most dangerous form.
Right.
It took away all of their safety devices, all of their resource sharing websites, all their ability to communicate with each other, to talk about bad dates, to talk about dangers to themselves, what to do if they have to call an ambulance, very important life-saving skills, and criminalize that discussion by forcing the platform operators to eliminate all of that speech from the internet under penalty of decades in prison.
Boy, we sure showed them.
And this isn't something that was even asked for by the anti-trafficking advocates. I mean, that's something that a lot of people don't realize. When this FOSTA SESTA bill was passed initially, and the advocates were pushing for it, they wanted something that would prohibit and criminalize sex trafficking on the internet. And yes, they wanted to roll back Section 230, protection for sex trafficking activities. But during a House committee hearing, a few representatives decided, well, as long as we're talking about trafficking, we might as well prohibit all consensual sex acts too, and create a brand new federal law that prohibits promoting or facilitating prostitution on the internet. So this isn't something that the advocates wanted. They probably knew that this would result in tremendous damage to the consensual sex work community and result in countless deaths and a hostile environment for people in which to work. But that's what a few senators decided was important, and that's what we ended up with what many have called a Frankenstein bill that was just thrown together in a patchwork piece of legislation that received very few hearings and very little debate, and it was pressed under pressure so that you weren't, as a legislator, voting in favor of trafficking.
Right. So now we flash forward to the year 2020. And by the way, the statistics are so raw and so easily accessible that the notion that the same crew would dive right back in and try and expand on their earlier efforts is astonishing. But the Earn It Act, what specifically are the attacks on 230?
So the Earn It Act now is one piece of legislation that is designed to force all the platform operators to earn their Section 230 immunity. So essentially, it's removed, and as a platform operator, you're responsible for third-party content, you're responsible for lawsuits, defamation claims, invasion of privacy claims, any wrong that occurs on the platform. The operator can now be held responsible for, both civilly and criminally, unless they somehow earn their Section 230 immunity based on implementing some undefined, unstated standards that a group of politicians will essentially put together at some point in the future. And the focus is going to be on, making sure that there is no illegal content online, that there have been filters put in place to bar underage content, age verification, parental filters, essentially a goodie bag, a wish list of how the government wanted to regulate the internet for the longest time but couldn't get away with because of the First Amendment. So they saw that FOSTA SESTA was the way to do it, that this is how we get around the First Amendment, which we don't think they can. But what they're claiming is we'll just have the platforms do our dirty work. If they want this Section 230 immunity, they're going to have to be the censors. They're going to have to be the ones that sanitize the internet and make sure that there's no sexually explicit content or anything else we don't want, whatever this group comes up with in terms of standards and practices. And then we will have the platforms, again, do our dirty work. Mm-hmm. There's an amendment to the Earn It Act that would essentially eliminate all protection for any underage content that's published by a platform and allow the states to enforce 50 different state laws on distribution of child pornography, many of which statutes do not have an intent element, which essentially means that the platforms could be sued or prosecuted if underage content somehow appears on their website, even if they don't know about it.
Right.
So what will that do? That will make sure that all sexually explicit content is eliminated from these platforms so as not to have to take any risks of prosecution.
And if I can put this on a personal level, for anyone who's ever had the sheer joy and fun of moderating a Facebook chat room and seen how that can get out of control in amongst even a few hundred users and how silly and childish that can get, imagine extrapolating the volume of that maintenance, that work, that sort of pervasive monitoring that has to go on across, to infinity. I can't even imagine how many billions of views take place on the internet, how many millions of comments are placed, the ability, for example, of folks to disseminate links across social media platforms like Twitter and Facebook, upon which shows like this, for example, just in the most banal of levels, rely on in order to get our political viewpoint, our radicalism, our debate, our perspective out into the world. Countless organizations like my own here rely on the ability to share those. That, I would imagine, would become a practical impossibility. You would simply not be able to place links out there because is the platform even capable of understanding those links? How many university forums would be eliminated because of the practical impossibility of a local university or even a major one like a Harvard or a Brown be able to monitor its content so that they are, if you will, protected from criminal prosecution? Again, it's impossible. It really is a practical impossibility for the tech providers. There's too much information passing through their networks to be able to monitor it in any real time. There's no reliable artificial intelligence or filters that would parse out
appropriate versus inappropriate content, whatever that means. And so the automatic default response is going to be to over-censor, over-moderate, and eliminate anything that's even close to the line.
And what kind of world would we have then? What type of effective political opposition would in a country like the United States be able to maintain? Then take that into other parts of the world. Well, let's keep it home for a second. You know, you've got to, and again, I'm political. I'm not going to ask our guest to be, but I'll just make the comment that you've got a president in place right now, from my perspective, who is clearly interested in suppressing opposition. Now, am I trying to draw moral equivalence between him and some dictator? No, I'm not doing that right now. But again, the level of political persecution that can take place as a result of individual governments weaponizing this type of law is boundless, absolutely boundless.
No question about it. And you know, the difficulty we have here is that we have no idea what the standards or practices will be that this group is going to put together in order to earn your Section 230 immunity. And you know, the concern is that the standards will change depending on who's in power and depending on who wins, you know, the next election and the next election after that. The whole point of Section 230 and really the ethos of the internet is free speech,
right?
Democratization of speech. And the Earn It Act and FOSTA and all of the other pieces of legislation that require platforms to moderate and censor under penalty of losing Section 230 immunity are antithetical to our basic principles of free speech and internet freedom.
Now, this, by the way, just isn't the adult entertainment community coming out against this. You've got as varied a groups as the American Civil Liberties Union is pointedly attacking this. You've got a range of third-party political organizations attacking this. Organizations which are predominantly free speech based, but at the same time, highly principled organizations like the Electronic Frontier Foundation who are attacking this, as well as the commercial interests for whom this would be a death sentence, literally an electronic death sentence. So the question comes, Attorney Walters, I mean, you've swam in these waters for years. You were there at FOSTA and SESTA. For the love of God, why do senators, and I'll just mention the principal behind this, which is Lindsey Graham of South Carolina. Go Gamecocks, you guys must be proud. What is their motivation appealing to their base? Is there motivation, are we looking at 21st century Tipper Gore's gone mad? What's going on here?
There's a lot that's driving it and competing interests. You know, in terms of FOSTA SESTA, it was a big push by anti-trafficking organizations to highlight the activities of a website called Backpage.com, which had eventually gotten seized by law enforcement, by federal law enforcement, without FOSTA SESTA. So, you know, the government always had the tools to go after this target that they'd been identifying as the primary concern that would be driving the need for FOSTA SESTA. But it's an issue like that of anti-trafficking that was driving the passage of FOSTA SESTA. And that morphed into an additional challenge and attack on Section 230 based on what conservatives perceive as censorship by large tech corporations. You know, you have a lot of people that complain that they're being banned by YouTube or Facebook or Instagram, what have you, based on their political viewpoint. And the response, the legal response to that is you don't have a First Amendment right to be on any of those sites. And so there is no legal claim to assert against those platforms. Lawmakers didn't like that. And so I would expect that the politicians that are pushing the Earn It Act are looking at ways to change the rules so that maybe these tech companies can be held responsible for discrimination, for political viewpoint censorship, et cetera. So it started with the nose under the tent of FOSTA saying, oh, well, we can all get together on repealing part of Section 230 based on a concern about trafficking. And now that we've successfully done it, well, let's use that same business model to accomplish all other political goals. And we've seen arguments for exceptions to Section 230 for trafficking, for drug trafficking, for terrorism, you name it. Whatever the issue is of the day is going to be the next exception to Section 230. Eventually, the exceptions will swallow the rule, and there will be no user-generated content online.
Right. You know, it's fascinating because as a libertarian, as frustrating as Twitter and some of these social media platforms can be to me, I ultimately respect their right as holders of private property to conduct their business in the manner in which they so choose, as long as it does not result in harm to someone, true harm. And so while platforms like MeWe, and there's a new Twitter competitor whose name escapes me at this moment, which is being supported by a number of culture warriors on the right of center in Congress because, you know, it's free and independent. Yeah, okay. They are willing, and these are folks who, and my frustration politically, these are folks who drape themselves in the American flag and the Constitution and a very selective interpretation of the Bill of Rights. And when it comes to the amendments, truly believes that the legal protections begin and end at the Second Amendment, an amendment I support, by the way, and are loath to think about the First, the Fourth, the Ninth, all those other trivialities that are out there. They are willing to, if you will, be so intellectually dishonest that they would ignore what are clearly the ramifications of this legislation. It's astonishing. They're all about.
It really is.
Go ahead, buddy.
It just shows the short-sightedness. You know, if they can accomplish an immediate political goal to satisfy a perceived need, the damage to the internet for generations and generations is somebody else's problem.
Right.
And, you know, that's where we have a serious concern. That's where, you know, our firm has jumped in and filed a challenge to FOSTA SESTA. And if the Earn It Act comes about, you know, we'll probably be in that one too, because somebody has to stop these efforts to eliminate all user-generated content online and squelch the voices of American people.
Right.
The platforms are the key to getting our message out, and you've got to protect them. They've got to have Section 230 immunity. Yes, there'll be bad actors. Punish the bad actors. Don't shoot the messenger. Right.
It's fascinating that very same group who will point out to the plethora of laws, if you will, that exist already on the books to be enforced against people who are involved in gun crimes, and will use that as a defense against existing or continued efforts at, if you will, diminishing the right to bear arms, will turn around and use that same logic that they so loathe on the Second Amendment against the First and the Fourth. And the notion that a incredible case of whataboutism will ultimately impact not only our economy, but the fundamentals of our democracy is astonishing. From people who, quite frankly, do know better. Now, we've only got a couple minutes left, but I want to hear about the Woodhull Foundation and their efforts in attacking, if you will, FOSTA and SESTA, if you don't mind.
Absolutely. Be happy to update you on that. As I mentioned, FOSTA SESTA was passed in 2018. We represent a nonprofit organization in Washington, D.C. called the Woodhull Freedom Foundation. It's named after Victoria Woodhull, a suffragette who fought for women's rights and the right to vote, and an outspoken sex-positive advocate. And this organization stands up for sexual freedom. It's the only group that is devoted 24/7 to fighting for sexual freedom. When FOSTA SESTA was passed, we were getting ready for a summit. And this is a yearly summit that involves a bunch of sex workers and others, academics and politicians and other thought leaders that get together and talk about sexual freedom and sex worker rights and related issues. We often have sex workers as presenters that will talk about their experiences and, you know, what's happened to them, et cetera. Every year we have a website that promotes the forum and lists all the speakers and their contact information and their bios, et cetera. And as we were getting ready for that summit, we realized that this FOSTA SESTA law, as literally interpreted, would stop us from promoting that summit because we would be promoting or facilitating potentially prostitution by promoting these sex workers and providing their contact information and advocating for sex worker rights. And we really struggled with the ability to continue promoting that summit and quickly realized that we need to do something about FOSTA SESTA. We need to challenge it. We need to try to put a stop to it. When we started mentioning to others that we're going to go and file a lawsuit, we had some very powerful interests that aligned with us. Archive.org and Human Rights Watch and several others, the EFF, as you mentioned, are supporting us. And we filed a lawsuit. It's been a couple of years now that we've been litigating. At the beginning, the initial court ruling was that our plaintiffs did not have legal standing to challenge the law, which we always believed was wrong. And we learned, in fact, that that was wrong by the appellate court, which ruled in our favor and said that the plaintiffs do have standing to challenge the law. And as of today, in fact, we just got a court order from Judge Leon in the district court in Washington, D.C., setting a briefing schedule for the constitutionality of FOSTA. And so we expect that all the briefing will be submitted within about 2 months, and then a oral argument date will be set shortly thereafter. Hopefully the courts will be open, and then we'll get a ruling on whether FOSTA is constitutional or not. Now, we challenged it on First Amendment and Fifth Amendment grounds. Again, this is a law that forces the platforms to censor speech. It selectively removes Section 230 immunity. And incredibly, it applies to activity that occurred either before or after the law was passed. So if your actions violated FOSTA before the law was passed, you can still be prosecuted under FOSTA now, which any first-year law student could tell you is a violation of due process. But that's one of our legal challenges.
To put it into human terms, and I know you're intimately aware of some of the travails, if you will, that a lot of these small city-based local support groups that are running into. There's a national organization called SWAP Behind Bars. SWAP stands for Sex Worker Outreach Project. There are chapters in cities across the country. SWAP Behind Bars has got a very special mission. They reach out to men, women, trans who have been incarcerated and provide them with support services while they're incarcerated, as well as provide them with potential support services, networking, some help financially whenever they can to folks who are leaving prison. If you will, I've had the opportunity to meet a number of the folks who volunteer there, and if there was truly the Mother Teresa's, if you will, the sex workers movement, I hope I'm not being too bold to say it's some of the folks working, all the folks working really for SWAP Behind Bars. They came to the realization, anecdotally, that some of the communications that they've got between folks who are either involved in the judicial system and or are incarcerated could be potentially in violation of FOSTA SESTA merely because they were in communication with them, offering them support services, which can be loosely construed to be involved in violation of whatever act, the Mann Act, whatever, because they are quote unquote aiding and abetting in the process of sexual conduct, sexual work, and support of sex workers. It's ludicrous, absolutely ludicrous. Defies common sense at a level that even a libertarian is shocked by, and again, it places people in raw physical danger. People are dying because of this law. That's not rhetoric. That's not hype. It's reality. And I'm astonished that national organizations like Day One would not be, who pledge to support folks who are looking to, quote unquote, leave the life, would support either tacitly or demonstrably this type of legislation. It's possibly one of the most appalling things I've seen in a fairly long life. What are your thoughts, sir? It
is. There's a true human cost to this law. The death rate is up amongst sex workers. The incidence of sex trafficking is up against sex workers. As you can imagine, if you take away all the tools to allow a sex worker to run her life, run her business, you're going to force those individuals in the hands of very dangerous people. Mm-hmm. And that's exactly what happened. It's exactly what everybody said would happen when the law was being floated, and exactly what we predicted happened. It is astounding that there are not more groups that are willing to stand up against this law and fight against it. I'm calling out particularly the Internet Association that represents the large tech companies that, after a period of opposing FOSTA SESTA, suddenly turned tail 180 degrees and decided, yeah, this is a great idea, we're going to support it. It's astounding that they didn't see the potential for damage. And I suppose in some ways it might give a monopoly to the large tech companies who can afford, the filters and the photo DNA and all the tools that's necessary to potentially weed out bad actors. And it may be that, Congress wasn't interested in going after the large tech companies for a violation of this law. So, they didn't oppose it. But you would think that any right-minded person that understands the Constitution or that depends on the Internet for their business would be terrified by this law.
And the moral hazards are clear. If you tolerated FOSTA and SESTA, if I can play upon an old tired cliche, and you thought that was the end of it, guess what? They did come for you. And if you're a platform provider, you are now about to pay the price if this is allowed to become federal law. So at a certain point in time, you have to say to people, it's time to wake the hell up and strenuously object to it by do-gooder representatives who are clearly do not have the interest of the type of folks who they believe, not me, certainly not you, sir. Our firsthand experience tells us that we've met folks with true nobility who have been able to overcome some of life's harshest circumstances through employment and sex work. But for these folks who look down upon these folks as, folks who need to be saved from themselves, folks who need to be, I can't even begin to understand the logic. But there is a line in the sand, and the initial one was crossed. The final one, if you will, is about to be crossed. And while the nation obsesses over whether or not you can get ice cream without wearing a mask, while the nation obsesses about death count versus, virulently ill count, while the nation obsesses about the infractions upon their civil rights because of a damn mask, the rights that matter, and believe me, I'm a libertarian, all rights matter. Play on words, right? But the rights that truly are fundamental to the free society that we think we live in right now are about to be ripped apart from you. And I guess my last question would be, do you think that's an overreaction?
I don't think so at all. This is an all-hands-on-deck moment for freedom on the Internet, for free speech generally. As you mentioned, the FOSTA SESTA law represented, kind of the shot over the bow. Well, we'll pick off the sex workers because they don't have a strong lobby. But as we saw, virtually all sexually oriented speech was sanitized from the large platforms after that law was passed. Dozens of websites went dark, shut down, went overseas where they can't cooperate with law enforcement. So that was the initial camel's nose under the tent. If we allow the Earn It Act or any other challenges to Section 230 to become law, we might as well forget about having any voice in the marketplace of ideas online.
Attorney Lawrence Walters, he heads up the Walters Law Group based in Florida, with the astonishingly straightforward, prescient, and on-target domain name of firstamendment.com. That's spelled first, F-I-R-S-T, amendment.com. They are truly warriors in free speech. They embody the notion that free speech, which may be uncomfortable for some, is worthy of the big fight. Throughout the years, organizations like the ACLU and folks like Mr. Walters have taken on what society has decided are its most unpopular examples of free speech violation. But in doing so, they are the last line of defense in allowing you to have the type of full life that the First Amendment affords. Thank you so much for joining us, sir.
It's been a real pleasure. Thank you for your voice out there, and happy to participate.
Well, I hope when issues come up, when issues arise, there's plenty more to go into on this, that you or folks in your firm will join us. It's critical that independent media, which is freed of the shackles of some of the commercial concerns that quote unquote big media has, the local newspapers, the local television, won't pay attention to something like this with the degree, with the focus that it so desperately needs. I hope you'll join us repeatedly as we amp up our outrage and our physical, if you will, political fight against this. This is an election year. Your vote matters, and these are the type of issues. These are the type of issues that matter. We are the Coalition, loud and proud, outrage porn free, civilly disobedient media, broadcasting live on the worldwide Coalition Radio Network at coalitionradionetwork.com. We hope you'll join us and like us and follow us at facebook.com/The Coalition Radio, on the mighty Twitter at Coalition_radio. And of course, take a moment, if you will, to go back to our old site, coalitionradio.us, where you'll see analog, digital, the old stuff. But there's a lot of history there. I'm proud to say we've been on the air for 8 years now, and we're not going away. If you're just catching this, we will be having this played on repeat on our Facebook platform, as well as our YouTube platform. You can join us again at facebook.com/The Coalition Radio. Have a wonderful night.